Welcome, everyone. We're going to give a few moments for people to trickle in and join the room. And once we have a critical mass, we will get started. All right, the number of participants joining seems to have leveled out, so we're going to get started. Welcome, everyone, to our event on children in armed conflict. My name is Ben Crawford. I am an IHL Legal Fellow with the American Red Cross, and I am joined today by Bethany Ellis from the Watchlist on Children in Armed Conflict. Bethany is the Senior Advocacy Officer for the Watchlist, where she leads the network's advocacy efforts to strengthen and support the implementation of the United Nations Children and Armed Conflict Agenda. In that role, she serves as Watchlist's primary liaison with UN member states, particularly members of the Security Council and its working group on the Children and Armed Conflict Agenda. Prior to joining Watchlist, Bethany conducted research and policy analysis for various global human rights organizations on issues relating to human trafficking, education and emergencies, and the rights of refugee and migrant children. Bethany, it's so great to have you with us.
Thanks very much for having me.
Yeah. Now, if we just want to dive in and get started, Bethany has a wonderful presentation for us, and then we will have a discussion, which will be supplemented by Christian Jorgensen, one of our IHL team members, and then we will open onto a Q&A for any questions that the audience may have.
Great. Thanks very much, Ben. I'm going to go ahead and share my screen so I can pull my slides up here. Okay. Here we go. Are you able to see the presentation? Okay, wonderful. Well, thank you so much, Ben, and thank you to my colleagues at the American Red Cross for inviting me to speak today. As Ben mentioned, my name is Bethany Ellis, and I'm the Senior Advocacy Officer for Watchlist on Children in Armed Conflicts. I've been leading our advocacy efforts, particularly at the UN Security Council, since late 2019. So I'll start off with a brief introduction of who Watchlist is. Watchlist on Children in Armed Conflict, or I'll just call us Watchlist going forward, is first and foremost, we are a network. So we are currently comprised of 16 member organizations, including both human rights and humanitarian organizations, with a wide range of expertise, experience, and programming globally. We were established in 2001, and our mission is to end violations against children in armed conflicts and to guarantee their rights. As a global network, Watchlist builds partnerships among local, national, and international non-governmental organizations, enhancing mutual capacities and strengths. And working together, we collect and disseminate information on violations against children in conflicts in order to influence key decision makers to create and implement programs and policies to effectively protect children. So a little bit more on how we do that. We are the leading NGO advocacy network working alongside the UN to strengthen implementation of their Children in Armed Conflict, or CAC, agenda. We have 3 key program areas, including research, advocacy, and partnerships. I'll speak a little bit more about our advocacy since that's my particular area of lead. Within our advocacy, we work very closely with the UN Secretariat, particularly offices and agencies that are relevant to children's rights, as well as with diplomatic missions in New York, in particular members of the Security Council, where we develop recommendations and advocate for specific actions to strengthen the protection of children's rights in armed conflict, including global policies and good practices on child protection. We also work to ensure child protection concerns are considered and addressed throughout the work of the Security Council. So that also includes country-specific advocacy, for example, mandates of peacekeeping missions, or in other thematic areas on the Council's agenda that might have an impact on children's rights, such as counterterrorism or the broader protection of civilians mandates, for example. We also conduct targeted policy research on specific emerging topics relevant to the protection of children in conflicts, such as the detention of children, which I'll go into a little bit more depth later on in the presentation. In all our areas of work, we draw on the expertise and experience of our network members. So we've said a lot about the UN's CAC Children in Armed Conflict agenda. What exactly is the agenda? When we talk about the CAC agenda, I'm including all of the frameworks, both the frameworks for protection of children in armed conflict, as well as specific specialized tools and mechanisms that were created to support that goal. So I'll take a look at a brief overview of the history and the evolution of the agenda, and then at some particular tools that Watchlist regularly engages with. So the UN CAC agenda started with the General Assembly resolution and has led to the development of a whole body of resolutions and policies under the Security Council that are implemented by UN agencies and offices, as well as relevant civil society partners. So the creation, first of all, of the office and the mandates of the Special Representative of the Secretary General on Children in Armed Conflict, the SRSG's office, came about as a result of a General Assembly resolution following a report led by Graça Machel, published in 1996, on the impact of armed conflict on children. This was followed up in 1999 with the first UN Security Council resolution addressing children in armed conflict and putting it squarely on the agenda as a peace and security item. There have been now a total of 13 thematic CAC resolutions adopted since that time, the latest being in 2021. We won't go through all 13 of those resolutions, but I'm going to highlight just a couple here that are important for understanding certain tools we'll talk about. So in 2001, the Council's Resolution 1379 called on the Secretary General to include in his annual reports to the Council a list of parties who were recruiting and using children. So this is the birth of what is sometimes now referred to as the quote-unquote list of shame that's published once a year. And then in 2005, Resolution 1612 created two additional very important mechanisms for the CAC agenda, one being the Monitoring and Reporting Mechanism, or MRM, which verifies and reports on the 6 grave violations in situations of armed conflict on the agenda, and also established a subsidiary body of the Council, which is called the Security Council Working Group on CAC. So let's take a look a little bit deeper at each of some of the tools that we interact with very regularly in this agenda. First of all, the Office of the Special Representative. The current Special Representative is Ms. Virginia Gamba, and the role of the Special Representative is to strengthen the protection of children, to raise awareness, to promote the collection of information about the plight of children affected by war, to foster international cooperation to improve their protection. She reports twice a year, once to the Human Rights Council and once to the General Assembly in New York. And she also will address certain other political bodies and members of the UN system, including the Security Council or other Security Council bodies, such as sanctions committees, on updates that are relevant to the protection of children in those situations within their mandate. The Secretary General reports annually to the Security Council, and this includes information on the various armed conflict situations that are on the CAC agenda and the MRM verified data on these violations for a reporting period of 1 year. And this also includes the annex list of perpetrators when this report is released. So for example, the latest report, which came out this year, it was published in this June, and it covers a reporting period from January 1st to December 31st, 2022. The monitoring and reporting mechanism, which of course was established by Resolution 1612, is the formal mechanism to monitor and report on the 6 grave violations. A little bit more on those next. The purpose of the MRM is to provide for a systematic gathering of accurate, timely, objective, and reliable information on the grave violations committed against children. The data is used in UN reporting, including the annual report, but also country-specific reports to the working group, as well as to inform action by the Security Council and others, and informing response services for impacted children, and engaging with parties to conflict to foster accountability or compliance with international child protection standards. The MRM has rigorous standards of verification, so it doesn't capture every incident, but it is unique in that the data that is presented in the annual reports, for example, is verified data. And the MRM is established in every country situation where parties to conflict have been listed in the annexes of the annual report. So that's once you're listed in the quote unquote list of shame, then that situation will get a formal MRM established. And then the MRMs are managed in country by what's called a Country Task Force on Monitoring and Reporting, or CTFMR. Sorry for all the acronyms, it's inevitable with the UN here. The country task forces are co-chaired by UNICEF and the highest UN representative in country, and they collect information, they verify reports, they respond to grave violations, they engage in advocacy, and they also notably negotiate and work on implementation for action plans, which are time-bound, concrete commitments established with the UN to end and prevent violations for which the parties might be listed. And then finally, the Security Council Working Group on CAC. So that was also established in 2005. The working group reviews reports of the MRM on country-specific violations against children, and they'll use those reports to adopt what are called conclusions, which include recommendations for parties to conflict, for relevant government officers, for the Security Council, or for action by the Secretary General, and to other relevant stakeholders such as the donor community, for example. Every member of the Security Council is a member of the working group on CAC, and their conclusions are adopted by consensus. In addition to the conclusions, the working group members have what's called a toolkit of actions that they can take in addition to conclusions that might include things like press statements, field visits. The working group just concluded their most recent field visit in July to Nigeria, and engagement with the country task forces. All these mechanisms are primarily focusing on the 6 grave violations. So let's now look at what those are. So the 6 grave violations include recruitment and use. This can mean using child soldiers, for example, in combat roles, but this can also mean using children in various other non-combatant roles, such as porters, spies, messengers, cooks, and it does impact both boys and girls. Killing and maiming, both direct as a result of attacks in a conflict of in a situation of armed conflict, but also can include things such as deaths of children and injuries of children by landmines, explosive remnants of war, and other indirect consequences. Rape and other forms of sexual violence, fairly self-explanatory, but also includes things like sexual slavery, forced marriage, and enforced sterilization. Again, we understand that rape and sexual and other forms of sexual violence is generally understood to be fairly underreported, particularly because of stigma. But we do know that it impacts both boys and girls in conflict. Abduction, attacks on schools and hospitals, and that includes attacks on related personnel. And finally, denial of humanitarian access. Now, when the list of shame was originally mandated in 2001, the perpetrators that were listed in those annexes were only those who were responsible for the recruitment and use of children. In subsequent resolutions since that time, additional violations have been added as what we call trigger violations, where if a party to conflict is found to be committing a pattern of these violations, they would also then be included on this list of shame. So now 5 of the 6 violations are trigger violations that could include listing of a party to conflict. So the only one that's not currently a trigger violation is the denial of humanitarian access. So the MRM focuses on these six, and the CAC agenda broadly focuses on these 6 grave violations, but they also pay attention to some of the other ways in which children might be impacted by armed conflict. For example, children might be displaced during armed conflict, which might leave them vulnerable to additional violations and abuses, such as recruitment and use, but also sexual exploitation, child labor, separation from their family, or physical trauma. They might be displaced internally or across borders. It might happen once or multiple times throughout the course of a conflict. The military use of schools is not specifically a grave violation, but it is reported on in the annual report because of its connection to attacks on schools and hospitals. So though not a violation in itself, the use of schools and education facilities by armed actors might disrupt children's education, or it might make a school be seen as a target for attack by an opposing armed group, or it might involve damage or destruction to a school property. And then finally, detention, which we'll look at in a little bit more depth later. But according to data from 2022, in at least 18 countries affected by armed conflict, governments have imprisoned children suspected of involvement with non-state armed groups or other national security offenses. So all of the 6 grave violations are rooted in a legal basis of international humanitarian law, including human rights law, as well as international criminal law. So the Geneva Conventions and optional protocols, the Rome Statute, ILO Convention 182 on the worst forms of child labor, Convention of the Rights of the Child and its optional protocol on the involvement of children in conflict, and the African Union Charter on the Rights and Welfare of the Child are just some of the examples of the relevant legal frameworks that are at work here. Each of the 6 grave violations against children during armed conflicts may constitute grave breaches of the Geneva Conventions and their additional protocols. They might be violations of customary laws or norms of international law. They might be violations of obligations contained in the CRC or in OPAC or in other relevant international and regional human rights treaties, or they might be war crimes or crimes against humanity under the Rome Statute. Might be maybe a good moment here to pause and just mention that when we use the phrase child here, we are using the international legal definition of the child contained in Article 1 of the CRC, that is referring to a child as any person below the age of 18. In addition to these treaty frameworks, there are also a number of non-binding additional commitments that member states have developed and endorsed over the years that are relevant to the protection of children in war. And these together sort of create a package of protection for children. And each of these also includes a robust civil society partners that are constantly creating lessons learned, research reports, and good practices about the implementation of these commitments for the better protection of children. So, for example, we have in 2007, the Paris Principles and Commitments were established. And these address the prevention of unlawful recruitment and use of children by armed forces and armed groups. They also address the release of child soldiers, including provisions in relevant ceasefire or peace agreements, on the release and subsequent treatment of children, and on reintegration of children formerly associated with armed forces and armed groups. And key to that is the treatment of these children primarily as victims rather than perpetrators. In 2015, we have the Safe Schools Declaration, which is about protecting education in armed conflict, and also covers not only schools that are covered in the grave violation, but also attacks on universities. And the Safe Schools Declaration also has accompanying guidelines for protecting schools and universities from military use during armed conflict. You have the Vancouver Principles that were established in 2017, and these are geared mostly towards troop and police contributing countries to US peacekeeping missions, but many of the themes underlying the principles can also be applicable to military and police operating outside of a UN mandate. These include some things as including child protection provisions in peacekeeping mandates, integrating child protection throughout all phases of the conflict, including prevention efforts, post-conflict, and recovery phases. And then the newest of all, the Political Declaration on Strengthening the Protection of Civilians from Humanitarian Consequences Arising from the Use of Explosive Weapons in Populated Areas, which is a very, very long title, so I will refer to it by its shorter title as the AWIPA Declaration, which was endorsed last November at a conference in Dublin. At that time, it was endorsed by 83 member states. And I've included this here in this sort of package of protection because children have specific vulnerabilities to explosive weapons violence, both physically and psychologically, and in looking at reverberating impacts longer down the road. And also explosive weapons is explosive weapons are a factor in, that we're seeing in almost all of the situations, country-specific situations of armed conflict on the CAC agenda. The CAC agenda has been effective in changing behavior of warring parties. Some examples of success is that over 170,000 children have been released from armed forces and armed groups through this framework. Over 30, I think at last count we were at 38 or 39. Time-bound action plans have been developed and signed by the UN to end and prevent violations against children. And in consequence of that, parties have been fully completed their action plans and then have been subsequently delisted from the list of shame. And there's a growing global consensus that children have no place in war. At the same time, there are still significant challenges to address. For example, you'll see the scale and the volume of grave violations against children continues to be staggering. In 2022 alone, the UN verified over 27,000 grave violations against children. And then again, that includes only those numbers that were verified. So we know that that might not be the entire picture as well. And there have been a growing number of country situations that have been added to the CAC agenda in recent years. This year, for example, Niger and Haiti were added as the newest situations of concern, bringing our total to 25 country situations that are included in the report, and one regional situation. And then finally, we see persistent disregard for international humanitarian law, impunity for violations against children, and shrinking civic space, among other challenges that continue to present obstacles to protecting children in war. And now I'm going to take just a couple of minutes to look a bit deeper at one specific topic that Watchlist has been interested in recent years, which is the detention of children. So these on your screen are the numbers contained in the latest annual report that show that in at least 18 countries experiencing armed conflict, children are detained or deprived of their liberty for their association, real or perceived association with armed forces or on national security related charges. The total there is verified 2,496 children in 2022, and this number doesn't include those who are being held in Al-Hol or Al-Raj camps in northeast Syria, which is a unique situation there. Though the detention of children is not a grave violation, we often see this harmful practice to children in connection to those who may have been recruited and used. So children have been in these cases doubly victimized. First, they've had to suffer through the violation of recruitment and use by an armed group or an armed force, for example. And then secondly, they're detained for their association and sometimes treated more as a security threat than a victim of a violation of their rights. A number of research pieces, including in-depth pieces by Human Rights Watch, for example, on detention in Somalia, in Nigeria, in Iraq, found that children in these circumstances frequently face physical violence. They may face sexual violence or even torture. They face psychological trauma, and they may face a lack of access to basic services, including nutrition, health, education, or access to legal services. And children are sometimes held on little or no evidence that they have ever actually committed a crime, sometimes without ever having been charged with a crime. For example, sometimes a child that may have been living under an area that was under the control of a non-state armed group and was able to flee that area or had to interact with the armed group in some way as a result of living in that territory may then be apprehended as a security threat. And we've seen this this trend is particularly apparent in situations where there are armed groups that have been designated as terrorists and where counterterrorism frameworks are in use that may not have appropriate safeguards for human rights broadly or for children's rights specifically. So what can be done about this? Watchlist has produced several reports in recent years on the effectiveness of handover protocols as a concrete tool to prevent the detention of children in these contexts. So what is a handover protocol? These are agreements by governments or armed groups to swiftly transfer children allegedly associated with armed groups or armed forces, or who they may have encountered in the course of military operations, to child protection actors for appropriate support services, including but not limited to reintegration assistance. And this is an explicit recognition by states and at times armed groups that children associated with these armed forces and armed groups are first and foremost victims of grave violations of international human rights and humanitarian law, and their reintegration should be prioritized. In this table here, you can see a list of situations where children have been detained, and the status of whether or not there is a handover protocol in place or under negotiation. This table was developed with our 2020 report on the role of handover protocols in preventing detention, and was updated in 2022 to reflect two of the latest adopted handover protocols in Burkina Faso and Nigeria. And these are just a handful of recommendations that Watchlist has in regard to the detention of children, including ensuring that children are treated primarily as victims, including those who may be allegedly associated with designated terrorist groups, and those who may have committed crimes, and prioritizing their reintegration. Consistent with the CRC, detention of children must be used as a measure of last resort and for the shortest appropriate time, and the best interests of the child must be a primary consideration. States should develop with the UN, assign and implement handover protocols to help facilitate the release of children and their access of reintegration and other support services. And then donors also can provide long-term and predictable funding for reintegration. Sometimes children are not able to be released over because there's no way, there isn't a child protection actor available to receive them, or there aren't resources to receive them. So improving the predictable and long-term funding available for dedicated reintegration services can also help to end the detention of children in these contexts. And then lastly, I have some further resources up here if you're interested in learning more policies and tools and training. And then we have additional selected resources from Watchlist, both on reintegration and on detention and handover protocols, and on CAC more generally. And I will stop there. I'm really happy to take questions and discuss more. Thank you.
Thank you so much, Bethany. That was fantastic. We will make sure for those further resources and recommendations, those will be available when we put this video on our YouTube page and beyond. So that is something everyone will have access to. But our audience has been wonderful and engaged, and we have so many questions. So we can dive right into some of those. To start, let's go with what are some of the primary advocacy strategies Watchlist employs to influence policy at the international level, and how can the general public help with this?
That is a great question. Thank you. So I'll say Watchlist uses a mix of advocacy strategies. I'll maybe caveat that we are a very small team in terms of our full-time staff, but of course we do represent a broader network. We focus primarily, though not exclusively, on the context in New York and the Security Council. So a lot of our engagement happens bilaterally with individual diplomatic missions. We try to provide resources for them on child protection norms and frameworks, on good practices, on good language that we'd like to see in negotiated outcomes, such as conclusions of the working group, for example. We also engage in some more public collective advocacy. For example, every year prior to the release of the Secretary General's annual report on children in armed conflict, we organize, for the past several years, we have organized an open letter that we prepared jointly with other members of the NGO community, calling on the Secretary General to ensure that his list of perpetrators is complete and creditable and accurately reflects the data presented and verified by the MRM in the narrative of the report. So we do kind of a mix of bilateral advocacy and more public-facing joint advocacy initiatives. And then, of course, our strategic research and the dissemination of our research pieces is also a key piece of how we advocate for specific policy changes that are relevant there. And how you can be involved, the second part of that. I think educating yourselves on the issues, sharing reports and resources and tools, including those that we've had on the screen, can be a huge help in just familiarizing more with both with the existing child protection standards, but also what resources are out there. In terms of actual support for Watchlist, we have typically one graduate level intern that we have per semester, but of course we have 16 member organizations as well, some of whom are quite large and who might be able to take on additional opportunities such as volunteers or other internships. So you can take a look at the members list on our website and see if any of those might be of interest as well.
Fantastic. Moving along here, let's see, given the vast scale of the issue, how does Watchlist decide which conflicts or issues to prioritize in this work?
Yes, yes, it is a big list. So essentially, any situation that is formally on the CAC agenda, which means any of the situations that are included in the annual reports, are part of Watchlist mandates. So currently we have 25 situations plus a regional organization that are on our mandate. So we are actively following and engaging on all of those to the extent that we can. Obviously, as certain conflicts might become more intense, we might have opportunities to engage more heavily on some versus others, but we try to make sure that we are also not neglecting situations that might not get, for example, a whole lot of international media attention in favor of those that do, because all of the situations in the report are on our agenda as well. So we do follow all of those situations.
Fantastic. Let's sorry, quite a few questions are all blurred together. What strategies and efforts are made to convince those armed forces, armed groups to sign on to and comply with these handover protocols?
Yeah, so I think the best way to talk about the handover protocol and negotiation and implementation is to refer you to a piece that we published last year, which is a comprehensive guide on exactly negotiating and implementing handover protocols, and that includes resources and information about, for example, which parts of a government you might want to engage and get on board when you're trying to lead up into this process on timing, and look at kind of where they are existing and where they've been effective and pulling lessons from that. So that was published and is in that list of resources in the spring of 2022, and there are translations available in English, Arabic, and in French for that resource.
Fantastic. Let's see. What is the status of stateless children under international law? Can other states exercise diplomatic protection on their behalf? And are there any examples of this that you've seen in international law? Bit of a multi-part question, I can say it again.
Well, I'll defer maybe to Christian about legal statuses on stateless children. I'll maybe just say in terms of grave violations, when the MRM is reporting on grave violations, they don't specify, in general, they don't specify the nationality of the child. If it's happened on the territory where the MRM is verifying information, that data would be included in the MRM, regardless if that child was a national of the country or not. If they're impacted by the conflict, that could be included.
Yeah, I can add on to that. So the issue of statelessness is something we often forget about, but it exists far more frequently than probably many people realize. And there are some things that the law says about it. It's mostly an issue of when it comes to international human rights law. So you have the Universal Declaration of Human Rights. Article 15 states that everyone has a right to a nationality. There's also a convention on the reduction of statelessness, where states sign on to it, promising to do whatever is in their power to not further the spread of statelessness. So this could be if a stateless person is in your country, denying them access to a nationality. There's also an earlier convention, 1954, relating to the status of stateless people. And then there's human rights. We could say like international human rights jurisdictions. For example, you have like European Court on Human Rights. You have the Inter-American Human Rights Commission and the court at the same time. And within that convention, as far as, for example, the Inter-American Convention, Article 20 also says that everyone has the right to a nationality. And then as far as examples go, there's plenty of examples to look at. So if you're looking for case law, you could look at those human rights courts and those regional human rights courts. So in Europe and the Inter-American Court, there was a famous case involving the Dominican Republic, where I believe two young girls were denied Dominican nationality. They were stateless, and the court ruled in their favor ultimately. But you can also look at things outside the courtroom too. So I'm going to apologize if my dog starts barking, but in Colombia, there was a huge growth of children born to Venezuelan migrants. And because of the breakdown with diplomatic relations with Venezuela, it was impossible for them to go back and assert themselves or even go to an embassy and assert their right to Venezuelan nationality. So you had children who were becoming stateless. So what happened was you can use your own country's constitution to enforce certain human rights. So Article 93 of the Colombian Constitution requires that the laws of Colombia fit with the Inter-American Convention on Human Rights, which I already said has Article 20 saying there's a right to a nationality. And you can use it that way to force policymakers to take away the authority of the National Registry in Colombia to deny those children Colombian nationality. So those are just some examples, but it's a fascinating subject and I could keep going on, but I won't. So.
That's wonderful. Thank you both so much. Popping right along. The questions continue to come in. We will answer many of them. I'm not sure we can answer all of them, but continue to ask them. We love seeing interest. Let's see. A question for Bethany, maybe we should comment this a little bit as well, of in armed conflict, there are a great degree of factors and changes and upheaval and instability that comes with the nature of an armed conflict. But what amongst those factors and changes have the greatest impact on children and are sort of things that would be warning signs or indicators that children might be at greater risk, implicitly or explicitly?
Yeah, that's a good question. Yes, I think one of the things you mentioned earlier on about displacement and the impact that that might have on increasing the vulnerability of children to be exposed to various violations and abuses, including the 6th grade violations, but other abuses as well. I think we're also seeing that as wars become prolonged and more wars are fought in urban contexts, that also has a very real impact on vulnerability of children, because it does represent sort of this blurring of the line between the traditional battlefield and what might have been previously safe spaces. And so we see things like explosive weapons and damage to infrastructure also creating, in urban conflict, also creating specific vulnerabilities for children. In terms of explosive weapons, there's a lot of fantastic research by Save the Children and Imperial College London about the specific physical vulnerabilities of children that make them more likely to have severe or deadly injuries as a result of exposure to a blast injury. And there's additional research that was released this year by the ICRC called Childhood in Rubble, that looks at specifically how children are impacted in urban conflict settings, including both physical impacts, but also impacts on access to their education, to healthcare, to proper nutrition, to sanitation, and also the psychological and mental health impacts that might have. Children are in a particular phase of both physical and sociological and mental development. So they sometimes perceive and experience trauma differently than an adult might. So I'd encourage, if you're interested particularly in sort of vulnerability factors, to check out some of those resources that are recent and very, very well done.
Fantastic. Thank you so much. An interesting question we've gotten. They're all interesting. This one, personally, I find very interesting. Some cultures around the world recognize adulthood occurring at younger and different ages than the West. For example, a culture may recognize marriage at a younger age, or the society may expect a young man to provide for his family at the age of 14. What resistance does the UN and other groups face in those cultures and countries, given that they have a legally defined age of 18?
Yeah, this has actually been a major point of advocacy in a lot of the special representatives' public statements this year in particular. And we really do align fully to her messages that a child is any person under the age of 18. And we are holding that line consistent with international law. And the Convention on the Rights of the Child is, has been ratified by every single member state except the United States in the UN. So it is one of the most broadly ratified human rights international treaties in the world. So there is, even in the Security Council, we see there is a lot of consensus around the protection of children and their rights, at least rhetorically. When it comes to practically, there might be very big differences, but rhetorically, there is a very strong consensus around this. So we just continue to hold that line. I mean, that is the legal framing. There are a whole lot of other pieces of research about, the specific developmental, physical, mental, emotional stages and ages, but legally, according to international standards on children's rights, a child is anyone under 18. So that is what we stick to.
Fantastic. Now, when we speak about detained children, does this refer to solely to orphans, or also to children that have been detained alongside their parents or other guardians?
Yeah, so we've seen both of these situations. I think most of what we've been looking at in terms of children detained for association, it's been children who have been encountered in the process of a military operation and have been detained either by security forces or in a prison. So they might be separated from their caregivers at that point. There are also instances that we have in our agenda of children being detained with their family members, with their parents. Libya comes to mind, where we know there are migration detention facilities in which children have been detained with their caregivers. Those are reported on regularly to the Security Council through the UN mission there. But then also we have this unique situation in Northeast Syria, where we have a large number of children who are being held for their family's affiliation with the Islamic State. Many of these children that are held in these camps are 12 and under and do not have any sort of evidence of themselves ever having participated in the Islamic State or committed any criminal activity in the course of that. They're being held for their family's association. So that's one kind of big exception there. That's a really upsetting situation that we've also done a bit of advocacy work around as well.
Great. This one, and this is something I'm sure Christian can chime in a little bit as well on, is how does the Red Cross and Watchlist work together in any way, if at all? Like, what parts of the mission do they both serve? And specifically more so for Christian, does the Red Cross have any programs in which volunteers can go and help in some way, either overseas or domestically, with the protection of children?
Yeah, so well, I'll say that for the so the Red Cross is made up of various separate entities. So you have the International Committee of the Red Cross, the International Federation of the Red Cross, and then over 190 national societies for which the American Red Cross is one. So how we work with Watchlist is doing events like this, where we try to have a dialogue on these important topics. And then because we have a shared interest in alleviating suffering wherever it's found, and their focus is on children and ours is general, but obviously that's an important issue to us as well. And it's a topic that we don't talk about enough. I think it's one that we read about a lot and we feel emotionally bad when we see children suffering, but we don't really have conversations like this as often as we should. So this is how we work together. So I won't speak for Bethany, but maybe she could tell us, do you work with the ICRC New York delegation or collaborate with them on anything when you're at the UN?
I'd say similarly, we've had some joint events that both ourselves and the ICRC have been a part of. One example is there was a side event during Protection of Civilians Week in 2022, in which both Watchlist and ICRC were co-sponsors, and that was looking at urban warfare and vulnerabilities of children. So the ICRC is present and advocating on all things international humanitarian law in New York. So we do also draw on the resources and analysis sometimes, and share relevance research such as, for example, the report I mentioned on childhood and rebel, looking at urban warfare as well.
Fantastic. Could you, Bethany, share a recent success story where Watchlist advocacy led to tangible improvements in the lives of children in armed conflict?
Yeah, it's a good question. It's a tough one to answer. I'll say partially it's a tough one to answer because so much of our work does focus at the Security Council. So we've got kind of, a win for me in the advocacy realm might mean getting specific language adopted in a conclusion of the working group or in a specific outcome product of the Security Council. But then implementation of that really does depend on others. So that's, I think, where a lot more of our network members' efforts and attention are going increasingly towards, we've got these really kind of robust systems in place for child protection. We've got a lot of good lessons learned. We've got a lot of good practices. We've got Paris principles, Vancouver principles, Safe Schools declarations, 13 thematic resolutions on children in armed conflict from the Security Council. And now looking at what does implementation actually look like? What does that mean? What kind of things improve the likelihood that a decision will be implemented on the ground? Are all things we're continuing to look more and more at. One of the things in support of that reality and the implementation on the ground that we do actively advocate for is more resources and dedicated staff for child protection in, for example, UN missions. So child protection advisors or child protection officers are specialized trained staff who are deployed in UN missions to be the focal point on child protection. So they might be participating in the MRM and working on verifying and reporting on grave violations. They might also be engaging with armed actors on the identification and release of children or on action plans. And they're also advising the whole of mission on child protection in the context, including, for example, what kind of provisions on child protection might be included in a negotiated peace agreement or a ceasefire, for example. So though there are good positive stories, that I would consider a win from Watchlist side, we do a lot of advocacy on around the annual report and the list of perpetrators, and sometimes there have been listings that were reflecting recommendations that we had really pushed for a long time, and those are positive wins for us. I'd say I engaged pretty heavily along with our partners around the negotiations for the most recently adopted resolution on CAC, which was 2601, and that was the first Security Council resolution looking kind of explicitly at the protection of education in armed conflict. So getting that resolution passed, it was passed unanimously. It had 99 co-sponsors. That was a big win, and we also got strengthened language in that around children with disabilities, around displaced children, around specific vulnerabilities of girls in the context of attacks on education, as well as language on mental health and psychosocial support. So getting the language in there now in the adopted resolution now gives us and our partners on the ground a lot more leeway to kind of advocate with national and implementing and armed parties to make sure that they're carrying forward those provisions. So I feel like that was a really long-winded answer, but hopefully that gives a little bit of nuances that sometimes with advocacy, it's really hard to just pinpoint that, this was a concrete change that was just solely to us. And also because I think with a lot of civil society advocating and at the international policy space, you're most likely not doing it alone. And in fact, you're usually much more effective when you're kind of collaborating with others and pulling towards a common goal. So it can then be hard to point back and say, hey, this was a really big win for us personally. But I hope that answers the question. And we're being recorded, but it's a pretty honest answer. So hopefully that's okay.
Thoroughly and genuinely answered. That's what we go for at the American Red Cross. Thank you so much. I think this may be our final question, but a question that once children have been rescued or sort of separated from AFAGs through handover protocols, you could speak on a little bit of what happens to those children. Do they get, are they connected with mental health services or like reconnected with families, or what is the process for them once they have been separated from active points of danger?
Yeah, so we in that circumstance would advocate for comprehensive, age-appropriate, gender-responsive programming to reintegration programming for those children. And I'll be the first to say, operationally, I'm not an expert on reintegration, so I won't be able to detail all of the various pieces that requires, but many of our members are actively involved in programs on reintegration, and they might include things like family reunification, mental health, education support, livelihood support. There are some who have programs around teaching local advocacy as well, and empowering and reintegrating children formerly associated to be able to identify problems in their own community and create solutions along with other young persons in their community in order to better their livelihoods, protect their rights, and then also potentially protect themselves from being re-recruited or others from being recruited in their community. So there are a whole host of sort of comprehensive services that might be contained in reintegration services, but all of those would be carried out by specialized child protection actors in the country.
Fantastic.
And there is a real need for more funding to support those programs because there's just not anywhere near enough for the need. And sometimes government funding, government donor funding might not be predictable and long term. They might have a grant for a year, but then not beyond that, when we know reintegration might need to be going on for a more sustained period of time. So I think it was the last recommendation in the presentation there was really around donor support that is long-term and predictable to support the creation and sustainability of these comprehensive services on reintegration.
Fantastic. And that our Q&A, as dedicated as they were, has run dry. So if you'd all join me through little participant emojis and thanking Bethany so very much for coming and speaking with us today and gamely answering so many questions. It has been absolutely wonderful hearing from you. And thank you all so much for attending. We hope you learned something. The recording will be available shortly after the fact, and we will make sure all of the resources Bethany linked and mentioned are easily accessible as well.
Thanks, everyone. Thanks so much for having me.
Thank you.